Hello, I'm Brian Tadros from the Law Office of Brian D. Tadros. We're going to talk today about whether or not you get your full wages when you get hurt on the job. Sadly, the law does not allow for that. So everything in workers' comp is a function of what is in the workers' compensation law. And the law only allows for you to get paid at certain rates depending on what your work status is. So at the beginning of most accidents or the life of most workers' compensation claims, you're probably going to be the most hurt. And so you may be on a no work status from your doctor. When you're on a no work status, that entitles you to receive what we call temporary total disability benefits. Those are benefits that are paid out at 66 2/3% of this magical term we use in workers' comp called your average weekly wage. I'm sure that you don't know what that means. That's why you're reaching out to an attorney or watching this video. But the average weekly wage in Florida is calculated by looking at the 13 calendar weeks of wages that you had before the calendar week of your accident. Those are added up, divided by 13, and that's your average weekly wage. Your average weekly wage is what determines what you're going to receive for any type of money benefit that is paid out in a workers' compensation case. So when you're on a no work status, those temporary total disability or TTD benefits pay you 66 2/3% of your average weekly wage. If you're on a light duty work status from the doctor, for instance, where they've given you restrictions of no lifting over a certain amount, no bending, no stooping, no pulling, etc., your employer will have to first determine whether or not they have work available for you within those restrictions. If they do, you have to go back and perform that. If you go back and you do that, the question is, do your wages fall below 80% of your average weekly wage? As long as you're earning at least 80% of your average weekly wage while you're working for your employer under light duty work restrictions, they're not going to owe you any what we call temporary partial or TPD benefits. However, if your wages fall below 80% of your average weekly wage, there is some money that may be owed to you, and there's a mathematical equation that has to be done to determine how much they owe you. If your employer does not have work for you to do within the light duty work restrictions that the doctor has assigned to you, then you get what we call your maximum temporary partial disability or TPD rate. That would be 64% of your average weekly wage. The only other money benefit that you get from workers' comp, unless you are what we call permanently and totally disabled, which most people do not qualify for, is what we call impairment income benefits, or IIBs. Those are a finite amount of benefits that you will get based on a percentage rating that a doctor assigns to you once you've reached what we call maximum medical improvement, which is the point at which no further lasting recovery is anticipated for your injuries. So at that point, you'll be assigned a percentage, for instance, at 3% or 6%. There's a guidebook that the doctors have to use to determine what percentage of permanent disability that you have. And based on that percentage, there's a finite number of weeks of benefits that you will get. Those benefits are paid out at 75% of your compensation rate, which is your temporary total disability rate, or the money that you get when you are on a no work status. So a small amount of people that get injured on the job qualify for what we call permanent total disability benefits. Those are people that are never going to work ever again in their life. And basically the standard is you have to show that you can't do even a sit-down job within 50 miles of where you live. And this is a function of what your work restrictions are from your doctors, as well as what your vocational background is, what prior jobs you've done, what work experience you have, and your education level, as well as your age. I often get asked, how long can I receive workers' compensation benefits for? And if you look at the statute, you'll see that it's 104 weeks, but that's been deemed unconstitutional, and the cap is now set at 5 years. So the maximum you can receive lost wages for is 5 years. However, it's unlikely that you're going to receive indemnity benefits for that long. Most people reach what we call maximum medical improvement within probably 6 months to a year, year and a half, depending on the nature of their injury and the severity of their injury. And the reason why maximum medical improvement is important is basically maximum medical improvement is when the doctors say that you're as good as you're going to get. Not that you're perfect, because you're never going to be perfect, but you've recovered as much as is anticipated for your injuries. And once you are at a point where there's no further lasting recovery anticipated, the doctor will place you at maximum medical improvement. And that kind of draws a line in the sand about your ability to receive what we call temporary benefits. So we talked about temporary total disability benefits, temporary partial disability benefits. Those are temporary benefits, benefits that you receive prior to you reaching maximum medical improvement. Once you've reached maximum medical improvement, the question is, are you permanently and totally disabled, or do you have a permanent partial injury? So if you have a permanent partial lasting disability, then you will be assigned a permanent impairment rating by your doctor, and that will entitle you to a certain number of finite weeks of benefits. I also often get asked, when will I receive my first check? Sadly, I can't give you a definite time period for that. If insurance companies did what they're supposed to do all the time, I wouldn't have a job. But you can expect that you're probably going to receive your first check approximately 3 weeks after the accident is reported to the insurance company by your employer. And that's assuming that your employer does what they're supposed to do and they report it to the insurance company. Let me talk about that for a brief minute. Sometimes the employer gets notified by the injured worker, but they don't tell the insurance company. Oftentimes, we have to be the ones that actually report the accident to the insurance company, and that's the first time the insurance company has heard anything about the accident. So again, I can't tell you when you're going to get your initial check, but typically within a few weeks, you should get your first check. There's something called the waiting period. So if you've heard that from your insurance adjuster, they are telling you what's correct. They don't pay you for the first 7 days of your disability, meaning of your period of time where you are on either a light duty work restrictions or a no work status from your doctor. So they don't pay you for the first 7 days of your disability unless your disability extends beyond 21 days. So if you are 22 days or later disabled, they will go back then and pay you for the first 7 days of your disability. If you've returned to work for your employer, or your employer doesn't bring you back for whatever reason, and you go start working somewhere else and you have wages, there are forms that the insurance company is going to send to you that you have to complete. These are called employee earnings reports. On those documents, you're going to have to indicate whether you've had any wages, whether you've had any unemployment, and workers' comp will use that information to determine whether or not they owe you any lost wage benefits while you've been on a light duty work status. If you fail to fill those out and return them to the insurance company, they're not required to pay you until you do so. So when you get those, you want to make sure that you complete them, but more importantly, you want to make sure that you complete it honestly and accurately, because failure to report wages that you're earning from other sources could be used against you in your case to say that you've committed insurance fraud or misrepresentation, as it's referred to in workers' comp, where basically you've made a false, incomplete, or misleading statement in pursuit of workers' comp benefits. And that is a road you do not want to go down. If you or somebody you know has been hurt on the job in the state of Florida, please reach out to us. We'd be happy to give you a free consultation. And if necessary, get involved in your case and make sure that you get the benefits that you're entitled to. Find us online at bdtlawfirm.com. If you found this video helpful, please like, share, and subscribe to the channel.